Good evening, ladies and gentlemen. Welcome to tonight's edition of HR Mentorship Learning Series. And we'll be looking at a very engaging topic, employment law compliance, an overview of laws that impact employee relations. And our speaker, our facilitator, our teacher for tonight is Barrister Emmanuel Abre, who is the Senior Counsel, Pinnacle Oil and Gas Limited. He's not a first-timer, he's not a stranger here. He has been of tremendous blessings and benefit to us in the past, and he has graciously agreed to come back again. Ladies and gentlemen, let's show some love through virtual emoticons as we welcome Barrister Emmanuel. You have the floor, sir.
Thank you very much, sir. Very grateful to be here once again. The last time was quite an amazing session, and it took me a while to recover from the reactions from that session, and I'm very much grateful to be here again. Today we'll be looking at employment law compliance, the overview of the laws that impact employee relations. So we're just going to have the content for today is not so much, but the nitty-gritties we're going to have to deal with will quite engage us for a while. And so I'll be taking you through the relevant laws or regulations that impact employee relations, as well as the case laws that the National Industrial Court has decided. Of course, law, as we know, it is not just the legislations that the National Assembly or the State House of Assembly has enacted. It's also the decisions of courts interpreting those laws or setting certain precedents that we have to rely upon in our day-to-day employee relations. So basically for today, there are two key things we're going to be looking at. We'll be looking at the relevant laws or regulations or conventions that impact employee relations, and then we'll then look at a number of cases that are impacting those areas as well. Now, compliance is not a glamorous area. It is, however, an area where HR must get things exactly right. As leadership assumes HR would have this issue perfectly nailed down. Successful compliance relies on knowledge of the regulations, experience in applying them, and appropriate processes and systems to maintain compliance day to day, week to week, month to month, and year to year. And this was what Ted Malley, the Chief Revenue Officer of Ceridian, said when he was still Chief Revenue Officer. He's gone on to be Vice President in the same organization, heading another department in that organization. He went on to say the HR department is the most important department in a company, from recruiting top target talent to employee engagement, relations which must be sensibly and sensitively handled, lest companies may soon have attendant reputational issues to deal with. Building, engendering, and sustaining a top culture or a top corporate culture. It all starts and ends with the quality of the HR in place. So again, HR must get things exactly right. Now, why must HR get things exactly right? Of course, we're not just saying HR should get things right. We are saying there has to be a level of precision in getting these things right. Now, the Nigerian business environment is almost replete with organizations that do not take compliance with labor and employment laws seriously. Many times in dealing with, companies, you find a situation where they just don't seem to think that these employment law compliances are that important. They feel that there are bigger fish to fry, there are better things to do. So why bother about employment law compliance? So you have a situation where a lot of companies have HR departments that are not manned by professionals. You have them, having people who do not have any HR experience at all or any training in HR, manning HR departments. In fact, in many cases, you find that the companies tend to fuse HR and admin departments together so that they can cut costs and all of that. Now, what are those labor and employment laws that are not currently being taken seriously that need to be taken seriously. The main statutes and regulations applicable to employment and labor relations in Nigeria are first and foremost the Constitution of the Federal Republic of Nigeria. And I'll soon tell you why the Constitution of the Federal Republic of Nigeria is crucial in employment relations. Then you have the Labor Act, you have the Trade Disputes Act, you have the Trade Unions Act, the Employee Compensation Act, you have the NSITF Act, the Factories Act, Pension Reform Act, Personal Income Tax Act, Industrial Trading Fund Act, National Health Insurance Scheme Act, Immigration Act, a lot of them, of course, including the National Industrial Courts Act. Of course, there's been a new act that was enacted in 2023, which is the Nigerian Business Facilitation Miscellaneous Provisions Act. And then, of course, the ILO conventions and recommendations, as well as the Nigerian Data Protection Regulations of 2019, and so on and so forth. Of course, there are a lot of them, and we may not be able to exhaust every single one of them today, but as we go on, I believe that we'll probably have other opportunities to look into the various acts. Now, to save time, I have not extensively dealt with every issue that any particular legislation might bring up, but I've tried to hit on the germane points in every one of the legislations that we're going to look at today. Now, we'll start with the Constitution, of course, because the Constitution is the ground norm of any country. It's the main legislation of any country. So we'll start with the Constitution. Now, because of the provisions of Section 254, subsection C of the National Industrial Courts, of the Nigerian Constitution, the National Industrial Court has jurisdiction in matters connected with unfair labor practice, and of course to apply international labor standards in interpreting the relations or employee relations in a company. Now, because of this, international best labor practices and labor standards are applicable to labor and employment relations in Nigeria. Many times, we find that employers seem to be more concerned about what the local laws state. In fact, in many handbooks, you would find that the employers are stating that they have committed themselves to the application of local laws in their companies, or local labor laws, or local laws on the area of employment law in their company. And it sounds very, very, altruistic. It looks like, okay, this is really a great thing this organization is doing. However, the Constitution states that the National Industrial Court can apply international best practices to labor relations. Why is this important? Because in drawing up your employee relations manual, in drawing up your employee handbook, in drawing up your internal processes and internal practices, you must think of you must factor in what international labor standards already say on those points that you are trying to, or those policies you're trying to draw in your company. If you do not put them into place, you might find yourself in a situation where, yes, you've complied with what you think is national law and practice, and then you find yourself on the other side of a compliance issue because you have not factored in what international labor standards prescribe. Beyond the fact of the international labor standards that employees or employers must comply with, the Constitution also compels HR to do certain things. In fact, the main thing, apart from applying international best practices and labor standards, is that HR must recognize and enforce certain employee rights. Of course, when I say HR, I'm really saying the company. But of course, as you would have heard me say earlier on, I said that the HR is really the most important department in any company. Maybe people in accounts may argue with that. Maybe people in operations would argue with that. Maybe people in procurement would argue with that. Maybe any other departments might want to take that glory from HR. But the truth of the matter is there's no company in operation who would do well or that will do well if they do not have the people to drive the business they are operating in. And that's where HR comes in. So what does the Constitution compel HR to do? The Constitution says you must, as a human resource personnel, recognize and enforce each employer's right to equal pay for equal work. Many times we find that in employment relations, you would have, let's say, 15 people in a department. And then because one person did not have a very good bargaining power at the beginning of his recruitment, he finds himself earning far less than other people in his department simply because those other persons were able to negotiate better for themselves. The Constitution does not allow you to do that. Interestingly, and many times people want to argue against this because they find that Section 17 of the Constitution is in that chapter of the Constitution that have always been argued to be non-justiciable. Non-justiciable because you really cannot draw a right from it. It is just what the Constitution refers to as fundamental principles of state policy. So people argue that, oh, Section 17 is not applicable. Now, even if you want to say that is true, Section 17 is applicable to the extent that there are international conventions that recognize this right to equal pay for equal work. So you cannot have in a department, a situation where everybody is doing the same amount of work, they have the same responsibilities, but then they are not being equally remunerated. It is wrong. It breaches the Constitution. It breaches international covenants and recommendations that are applicable to labor laws or labor relations, and it can put your company in the wrong side of compliance. Beyond just, having different people earning different things, you also want to be careful that you're not in a situation where a particular gender, let me not just say females, a particular gender in your departments seem to be earning less, even though they are doing the same things in the same company. So there's that right to equal pay for equal work. You must ensure that across board you uphold that. Then there's the right to humane work conditions and respect for dignity of human persons. Very important. You find in some situations where companies, seem to have a toxic work environment where everybody just talks down on everybody. There's disrespect. Workers are treated like they are just a factor of production. Yes, there used to be a time when workers were just a factor of production, but those days are far gone. The employee is not just a worker, as you might want to put it, is not just a laborer. He is an employee. So the relationship is no longer the relationship of a master and servant. It's the relationship of an employee and an employer. And because of that, that employee is entitled to his right to dignity of his person and humane work conditions. You cannot, for instance, place an employee under work circumstances that demean their person, that reduces them to, animals. That should not be done. Of course, there's the right against forced labor. And let me really sound this while I talk about the right to forced labor. Many times I have seen in my practice that employees would tender their resignation, and then HR responds and says, your resignation is rejected. Sometimes they have a point. Maybe that employee hasn't done certain things in the exit process. He hasn't done a proper handover. Or even if the resignation is accepted, the HR department is now looking for ways to enforce certain things. So you hold back on their exit entitlements, you hold back on outstanding salaries that should have been paid to them at the point of exit. You hold back on so many things to force them to do what you want them to do. That is forced labor. So whatever takes away the right of the employee to leave the organization at the time he wants to leave, changes the relationship to a slave and a slave master relationship. So you want to be careful with that. Of course, there's also the right to freedom of association. Now, this is where union rights or labor rights come into place. Every employee has the right to either join or refuse to join any union. So you cannot, as an employer, force your employees to join unions or stop them from joining unions. So under the Constitution, Section 40, they have the right to freedom of association, so they can join any union of their choosing. Now let's go to the Labour Act. The Labour Act is very important. It's the principal legislation. I just hope we are able to unpack everything that is in the Labour Act, including the distinctions you have to look at in, classifying your employees according to those who are bound by the Labour Act and those who are not necessarily bound by the Labour Act, but bound by the sacrosanct positions of their contract of employment. And the Labour Act is the principal legislation governing employment relations in Nigeria. It is applicable to employees engaged under a contract of manual labor or clerical work in private and public sector. Now, this is very important. The Labour Act in Section 91 defines workers as those carrying out manual labor or clerical work. It doesn't apply or doesn't state itself to apply to all categories of employees, but says it is applicable to those carrying out manual labor or clerical work. Other employees in the company are strictly bound by the provisions of their own private contract of employment. However, the Labour Act is a prescriptive legislation in certain instances. The fact that it is not all-encompassing or all applicable or universally applicable to all employees does not mean that all its provisions go to no issue for certain employees. So, for example, when you're carrying out redundancies, the position is that if you have employees who are not bound by the provisions of the Labour Act, then you must state in their contracts those provisions or those terms that would govern redundancies. When you have failed to do that, you fall back to what international best practice states. International best practice relates us back to national law and practice. The national law and practice on redundancies is the Labour Act. So then the Labour Act then becomes applicable in that instance to all other employees, even though they are not manual laborers or clerical workers. So that's just how the Labour Act operates. Now, what does the Labour Act compel HR to do? At the beginning, I had said that when I mention HR, I'm really talking about the company. But because HR is the chief compliance officer when it comes to employee relationships, this is what the Labour Act compels you as an HR officer to do. Number one, you must give your employees a written contract within 3 months of employment. The contract must be certain about the nature of the employment. Is it fixed employment? Is it a permanent employment? Is it just for a contract? What's the nature of the employment? What's the duration of the employment? What wages are payable under that employment? That contract of employment must state that. Now, you must give that employee a written contract within 3 months of his employment. Many times, employers try to be smart. They employ somebody orally. This person works with them for 6 years, 7 years, no employment. And then the person is terminated and the person believes that there are benefits that they should earn under the contract. Then the company comes to deny the existence of any engagement with the employee on the basis that there is no contract of employment. Now, that's error is really gone because the courts would always look beyond whether or not there's a written contract of employment, the court will look beyond that to go to the conduct of the parties. Were you paying him certain amounts of money? Were you paying him salaries for his work? There is always going to be proof of salary. Some employers can be so smart, or they'll try to be so smart, that they don't even give the employee any, pay slip or transfer the money to his account or anything. They deal with cash. Now, an employee who, after receiving that amount of money, always lodges that amount of money in the bank, has created a trail of salary payments by himself, so that in the event of a dispute, you cannot claim that you did not employ him, or that he was an independent contractor and not an employee. Payment of salaries must be in legal tender and in no other manner. You can't pay your employees with crypto. It has to be in Naira. Of course, I have already earlier said that the application of the Labour Act is restricted. So you would have a situation where someone has contracted to earn in a different currency other than the Naira, especially, senior cadre employees. That happens. And when that has happened, you cannot, as HR, deny that person of those benefits relying on the provision of the Labour Act and state that, well, we contracted to pay you in United States dollars. However, the law does not allow us to do that. We can only pay you in Naira. So you're now looking at whether you exchange the Naira value at the official rate, or you exchange it and you're trying to save money, by not exchanging it at the parallel market rate, and then you want to exchange it at the CBN rate so that you can save, the differential for the company and all of that. The law or the courts would hold you bound to the particulars of your contract so that you cannot run away from it. Now, of course, there are situations where you need to deduct salaries. An employee has taken an advance, salary advance, and then you need to take it back. So here's what employers, what I've seen employers do. Say an employee takes his February salary on February 3rd. Then when you're paying salaries to other people, you exclude him from payroll and say, well, he has already taken an advance. Now that's a general mistake HR makes many of the times. Now, salary reduction must, for that employee who is, a manual or clerical staff or a manual laborer, must be with the consent of an authorized labor officer and must not exceed 1/3 of the employee's monthly salary. So yes, it took a salary advance, but it took a loan. It took a car loan. It took a loan for paying his house rent. Somehow he has exceeded what should ordinarily be paid to him. In taking back the money, the employee is entitled to keep 2/3. 2/3. So you're dividing his salary into three, and then you're taking one portion of it and you're giving him the remaining two portions. Of course, that does not stop you from deducting other things that are statutory, pension, taxes. Those are not included in any of this. And of course, you're limited to the extent of things you can. So, for instance, an employee has done something that has maybe was negligent in carrying out his duty, and then it resulted to loss for the company. You're still bound by that. You cannot take it all out at once. Then you cannot prevent, as I've earlier said, you can't prevent your employees from joining labor unions. You must allow them an hour of rest if the employment period or the work hours exceeds 6 hours every day. Of course, maternity leave, 12 weeks for female, 12 weeks for female employees. But well, this is one area men have been discriminated against. So we don't get paternity leave, but of course, you know that there is there's currently a sort of reawakening. The federal government has approved that for federal government employees. Lagos state government, of course, has a provision for 10 days paternity leave within the first 2 months of the birth of the baby to allow for bonding between the father and the child. Now, there is no legislation compelling HR in private practice to do this. When I mean private practice, I mean those of you who are working for private companies. There is no legislation compelling you to do this for male employees. However, you can actually draw up a policy that resembles what the federal government has done, what the Lagos State government has done, to also allow your male employees some amount of time off for paternity leave. Then, of course, there are situations where there's transfer of employment. You have sister companies. It's still almost largely the same management, but different companies, distinct, legal entities. And you want to move your employees across board. You need the consent of, a labor officer to do this. Also, you need the consent of the employee himself to move him from one employment to the other. And that transfer must be endorsed by an authorized labor officer. In practice, really, the authorized labor officer is really the Minister of Labor and Employment. So the application for the endorsement, so let's say you're doing a large transfer of employees from one company to another, then you can just create a schedule of those employees, write to the ministry, and then seek. Of course, you must have obtained the consent of those employees, and there will be a document showing that they have consented to it, after which you can then transfer proof of that consent as well as a request for the endorsement of the authorized labor officer so that the transfer can come through. Many other things are still under the labor act, but I've just chosen the things I thought are very germane to your everyday practice. We now move on to the Employees Compensation Act. Now, let me quickly tell you what happened in one of the cases I was involved in, right? An employee was working in the bank, and somehow ergonomics were not really good, in the sense that the chair she was sitting on, what she described in her case was that the chair she was made to sit on was quite low, and she had a very high desk because she had to. Of course, many of those things have changed in the banks now, but if you recall, those days it used to be that you couldn't really see the cashier very well. You could really only see their head because of the way the workstation was, arranged. Unfortunately for this particular lady, it led to lumbar spondylosis, and then she started having issues with her spinal cord and the rest of that. Now, the bank did was that they started paying for her treatment, right? They, of course, they were very, very humane with her, and but everything they did really could not cure the issue. They sent her abroad for some operations. Unfortunately, the operations worsened the issue. And then the question was now, when she came to court, the question she was asking the court was whether she wasn't entitled to some form of compensation. Now, the bank was saying, well, we spent a lot on her, and we think that that should count in factoring whether or not she should be paid additional compensation. Unfortunately, the lady's case was so bad that she really couldn't finish the case, and for a period of over 18 months, she couldn't even come to court. And unfortunately, the case had to be struck out. Well, I don't want to say much to my delight so that I don't seem to be a wicked person, but I was representing the bank, and I found myself in a situation where I was really concerned about how I was going to cross-examine this lady when it got to that stage of the proceedings. So the Employee Compensation Act provides for the establishment and maintenance of a solvent compensation fund managed in the interest of employees and employers, and seeks to combine the efforts and resources of relevant stakeholders to compensate workplace disabilities, as well as enforce occupational safety and health standards. Now, there is a body that is responsible for the management of this solvent compensation fund that I have talked about. It is the Nigerian Social Insurance Trust Fund Management Board. Now, this body was established by the Nigerian Social Insurance Trust Fund Act and is vested with the powers to implement the provisions of the Employee Compensation Act. Now, what does the Employee Compensation Act compel you as HR or you as a management employee or the owner of a business? What does the Employee Compensation Act compel you to do? Section 33 sub 1 of the ECA provides that you as an employer or you as an HR personnel must make a minimum monthly contribution of 1% of the total monthly payroll into the Employee Compensation Fund, 1%. Now, the fund was established to provide compensation to employees and their dependents for any death, injury, disability, or disease that arises in the course of employment. Now, there's been so many debates. What does the course of employment mean? Is it what happens when I'm in the office? Does it include things that happen to me outside the office? And mind you, we have a lot of work from home policies in many companies today. So when I stand up from my bed, let's assume that I live in a one-bedroom flat and I just have a small workstation. And in the process of leaving my bed to come sit on my workstation, the oil that poured from the egusi and food that I ate the night before made me sleep and I hit, well, not me, in Jesus' name, but that person made the person sleep and then the person hit their head on their workstation table and then were injured. Is that an injury that occurs in the course of employment or not? So thankfully, so long as what has happened extends to the place where that person would have carried out your work, or on the way to the place where that person would have carried out your work, or on the way to get refreshments for doing your work, whatever it is, it has happened in the course of employment, and that employee is entitled to compensation. What else should you do beyond contributing 1% to the compensation fund? You must report that death, disabling occupational disease, or injury within 7 days of its occurrence to the board. If you do not, there are penal, provisions that could, penalize you in fines or even imprisonment. Well, not you, your MD, but it could lead to some form of exposure for your company, and you must take this very, very seriously. There have been instances where, in practice, even though the Employee Compensations Act does not provide for an extension of the period within which you can apply for compensation, in practice, when there's been an injury or a disabling occupational disease or death arising from work, you can write to the NSITF Management Board to extend the time for you to apply. So let's say someone got injured in the course of work on the 1st of April, 2023. For some reason, you forgot to report it to NSITF, or maybe, with your kind heart, you were trying to do certain things to, make the employee feel better. And then you did not report within the time you were supposed to report. What then happens? You can apply to them, stating the reasons why you were unable to report within the time, and they have the discretion to still accept your application and pay compensation. The question that many of us ask is this: what then happens to that employee? Because I find a lot of situations where, and I hope nobody will see me as a bad person after I say what I want to say. It's just what the law says. So I cover myself with the provisions of the Employee Compensation Act. What happens if an employee is injured and cannot continue working or cannot continue working at the rate you expect them to work? I've seen this a lot of times. One time I was in court in Port Harcourt, and there was an employee of a bank in court um, applying, or rather suing the bank for failure to compensate him for a disabling injury. Actually, the bank was robbed and he was shot, right? And because he was shot, he was shot on his left arm, and you could really see, even in court, that that hand was, I don't know what they failed to do, but the hand was really just dangling off his body. Now, there are situations where an employee can no longer be an employee to you because of an injury that happened in the course of employment. This is why there is an Employees Compensation Act to compensate that employee for the injury they have suffered. The schedule to the Act has the metrics for calculating what an employee is entitled to. Is this a partial disabling, or is it full and the employee is unable to do any work, or is that employee, just unable to work for you anymore? The answer is compensation. That is why you contribute to the fund. You really do not need to keep the employees. I'll give you a scenario. An employee who was more like a management level employee was trying to be nice. He saw some younger manual laborers. In fact, those persons were not even employees of the company. They were independent contractors who needed to help set up some machinery, right? And they needed to go get the equipment to move that machinery from one point to another point. He saw the machine and thought it was too small for them to be looking for that other equipment they needed to move it, and so decided to carry it by himself outside his work, work roles, or his job description. Carried it, and the next thing he heard was the sound of his back breaking. I'm sorry, I'm smiling. I shouldn't be smiling. I'm sorry, I'm smiling. Let me stop smiling. He heard the sound of his back breaking, and the question was, did it happen in the course of employment? I recall that the company had written and asked for a legal opinion saying, did this happen in the course of employment? Or was he just on a frolic of his own? And my answer was, he was on a frolic of his own in the course of employment. So he's entitled to compensation. The Employee Compensation Act does not really discriminate as to what you were doing in the course of employment. Did you just wake up from a nap at the office and decided that you're going to be hitting your head of the wall for no reason, and then you cracked your skull? The Employee Compensation Act does not have any provision saying because you did it foolishly, then you should bear your suffering by yourself. No. The Employee Compensation Act just says if an injury occurs in the course of employment, there's a foreign case I just remembered now, where a senior management employee was sent, outside the states for some conference, and then he decided to be happy, and he got, some very righteous ladies to join him in his hotel room and all of that, and then he almost died. Anyway, he came back to sue his employer for compensation for for that. Lucky for him, that court granted, I mean, not Nigeria anyway. I can imagine what the Nigerian judges would do. But that court actually granted him compensation, considered what had happened as having happened within because of his employment. So, what we take away from the Employees Compensation Act, you must make a minimum monthly contribution of 1%. Actually, under the Employee Compensation Act, this 1% is really the first payment you will make, 1% of your monthly payroll. Now, after you pay this 1% of your total monthly payroll, the NSITF board will now also determine what it thinks is fair for you to pay going forward. Sometimes your organization might be very large, and the 1% of your payroll you're paying might be a sizable amount of money. Now, the NSITF board, in their discretion, can decide, okay, pay 0.8%, pay 0.5%, pay 1.2%, you think you have the money, pay 2.5%, you think you have the money, but the minimum prescription is really 1%. But they have the discretion to do whatever they like to that going forward. I think we should leave the Employee Compensation Act and quickly go into the Pension Reform Act. It governs the administration of a uniform contributory pension scheme for both public and private sectors in Nigeria. Now, what are you compelled to do under the Pension Reform Act as HR? Remit your pension contribution to the PFAs or the PFCs within 7 days after payment of salaries. 7 days after payment of salaries. 7 days. If you fail to do that, then you have to pay not less than 2% of the total contributions that remain unpaid for each month that the default continues. So it's best to just pay that. And I know this can be an issue for some employers because they'll rather just meet your salary obligation for the next 7 months before they believe that they can raise enough money to, pay your. So you find that in some organizations, pension doesn't come as frequently as it should. So sometimes you find a situation that it's 9 months later they now, paying and a lump sum into your PFA. Well, it looks good, but it is wrong, and it can actually lead to liabilities for your company. Now, the percentage of contribution, of course, you probably already know that if you do not have up to 15 employees in your organization, it's dicey, but it would seem that the minimum you should have is 15 employees, but I'd rather you just comply. Really. So the employer pays 10% of the take home, well, not take home necessarily, but there's a way it's calculated, but 10% of that, and then 8% of it will be deducted from the employee's salary. Now, if you are that kind of employer that, they used to tell you, oh, it's plenty and you have plenty money, you can decide that you want to take up the entire burden of the contribution, which must not be less than 20% of the emoluments of the employee. If an employer fails, or if an employee rather fails to open a retirement savings account within 6 months of employment, then you, as HR or as an employer, must open a nominal RSA for the employee. This is why it is important. There was a case we were involved in. The employee was a foreign person, right? And he worked with that organization for 18 months or more. And they terminated his employment and he needed to leave the country. He sued and said, well, you were supposed to pay me a certain percentage. Now, that employer agreed to pay the employee, I think it was 5% or 15% of his, emoluments monthly to remit 15% of his emolument monthly as pension. They didn't do that all through the period of the employment. And then when the man was fired, or when he was fired and he left the company, he sued them and he wanted to, take that money for himself. Now, the defense counsel said, no, you can't take it. The Employee Compensation Act says it should be paid into your retirement savings account. You never opened a retirement savings account during the period of your employment with us. Court compel him to go and open a retirement savings account so we can pay his pensions into that account rather than paying it directly to him. Well, because of the unique circumstances of that case, the court directed that it should be paid to him. But what you should take away from this session is that if your employee fails to give you an RSA within 6 months of their employment, then you should open a nominal RSA for him and pay him his pensions into that. Section 4 of 5 also of the Pension Reform Act also provides for a group life insurance, which your company must maintain. In fact, the GLIP certificate should be even displayed, in a conspicuous place in your office. But you must maintain that group life insurance in favor of each employee for a minimum of 3 times the annual total emoluments of that employee. Now let's move on. I have lumped the trade union legislations together, and so we don't have to take them, one after the other. But under the trade union legislation, what do you need to know? You cannot prevent your employees from joining trade unions. You must not. Now, you cannot even prepare a contract that compels an employee to relinquish their membership of trade unions or renounce their membership of trade unions as a precondition for employment. You can't even prejudice any of your workers because they are in a trade union. Do that, it's illegal. And of course, it can lead to exposures for your company. Now, you also cannot force any of your employees to join any particular trade union. I know that sometimes some employers have certain unions that are operative within their companies. It is still the employee's right to decide whether or not he wants to join any of those unions. You cannot force him to join any trade union. Now, a lot of people within your company can be a thorn in the flesh. And I know I have experienced it many times where we are trying to negotiate with unions, not to, just cause a situation where the company is unable to operate. You just wake up one morning, you're whistling to the company, you're driving, and then you get to the gate. All your employees are outside. And then management starts putting pressure on you as HR to do something about it. Now, and you're just fed up. I just start screaming from the gate, all of you are fired. Your fathers are fired. Your grandfather is fired. Don't come back here again. Pack your shit and go. If you terminate anybody's employment because they were involved in any kind of trade union activity, that termination is unlawful. It is also not a valid reason to terminate their employment. In fact, the ILO Termination of Employment Convention 158 states clearly that union activity is not a valid reason for termination of employment. Now, you must not hinder trade union activities from holding outside official hours. Of course, there are fine ways to do this, extend working hours. And so long as what they are doing is not within your business premises, is not within official hours, they are free to do it. But if it's within official hours and within your business premises, they have to seek the consent of the organization to do that. So you may or may not, you don't want to give consent to them to do that. And then there's Data Protection Regulation 2019, which really states that any person who is entrusted with the personal data of, a data subject, in this case, employees, or who is in possession of the personal data of the employees, owes a duty of care to that employee and will be accountable for any act or omission in processing that data. Let me give you a live case. there is a case of Adewumi Akinola versus Ocean Marine Solutions Limited. This case was really a sad one because, well, they were trying to protect their own employees, and they had certain employees who worked in the kitchen. So for those employees who worked in the kitchen and were responsible for preparing food for the workers, they would usually send them for health status screening occasionally. Now, there was a time when they sent this particular lady was sent for health screening. And when she was sent to, they didn't give her the result. Of course, HR people again, that's what you do. You tell the lab not to give the results to the employee who is coming for the test. You tell them to send it directly to you. Now, you are a data processor as a result of that. You have the personal data of your employee in your care. You have a duty of care to ensure that you process the data properly and you do not divulge people's confidential information. In this instance, the lady got back to the office and found out that everybody was treating her like she was one of the Egyptian plagues. Nobody wanted to be served by her. In fact, HR even told her they went to go and stay at the security gate. Then the next day, she found out they didn't allow her enter into the office and all of that. Everybody was looking at her one kind. And they terminated her employment as a result of that. And she went to court and said, well, I was discriminated against. My confidential information was divulged to other employees and I was dehumanized. And the court granted about 5 years worth of her salaries as damages for that. And the company had to pay. Moving on, I would try to move on fast. The time is sort of getting fast. The National Housing Fund Act, by Section 4 of that Act, now there's been a new act, which is the Business Facilitation Miscellaneous Provisions Act of 2023, pardon me for 2022, I think, requires employees earning the national minimum wage and above in the public sector, or employees that are self-employed earning the equivalent of the national minimum wage and above to contribute 2.5% of their monthly salary into the housing fund. Now, this is compulsory for those of you who are HR practitioners practicing within the public sector. It is compulsory for employees within that sector to contribute 2.5% of their monthly salaries into the fund. But for those in the private sector, it is not compulsory, so it's optional. It used to be that you had to do it, but with the Business Facilitation Act, it is now optional. There's the Industrial Training Fund Act. That act provides, and again, this act is also has now been influenced by the provisions of the Business Facilitation Act. So it provides that an employer having 25 or more employees in its establishment and not operating within a free trade zone is obligated to contribute to the Industrial Training Fund 1% of its total payroll every year. Now, this is by virtue of the Business Facilitation Act. Of course, everybody knows about Personal Income Tax Act. So you know that there's the pay as you earn regime. And of course, you know that as an employer and as HR, when you're calculating or when you're drawing up payroll, the payee has to be deducted at source and remitted to the relevant tax authorities. And of course, you know that the due date for remittance of payee is the 10th day of every succeeding month. So you shouldn't go beyond that date in remitting. Now, I should let you know that deduction and remittance of payee is individual. So sometimes some companies have some funny practices where they claim to have paid taxes as a group. And then an employee maybe buys a property and wants to perfect his title, and then is asking you for his tax records, and there is nothing because you claim to have paid it as a group. I don't know where people got that idea from, but payee or personal income tax is personal to the employee, and there should be a record showing that the employee has paid their, of course, because you are the one responsible for deducting that money at source and remitting it to the relevant tax authorities. We also have the Immigration Act. Basically, the Immigration Act, involves when you have expatriate employees who are not, Nigerians. Then, of course, you need to have an expatriate quota. You cannot exceed that quota, and the the quota is fixed by the Nigerian Immigration Service. And of course, before you even say you want to involve an expatriate, you must be able to show that there is some kind of work the expatriate can do, which no other Nigerian can do. They have this skill that no other Nigerian has. And of course, even if you bring in expatriates, you must then make that expatriate train the Nigerians within your company to do that same thing. Of course, those things will count when you want to renew your expatriate quota. Now, we want to look at HR compliance through the cases. Of course, I said earlier on that it's not just what a legislation says that is law. When a court has interpreted a legislation or has decided on international best practice or international labor standards, those decisions are also laws that you as an organization or as HR must be very mindful of. Good thing is that the National Industrial Court has a judgment portal. That judgment portal, on that judgment portal, they report cases on almost a daily basis. So if you decisions from all the judicial divisions in Nigeria are usually uploaded on that portal immediately after they are delivered, not before. So you can know what the current position on certain things are, and you don't find yourself on the wrong side of a compliance issue. Now, I'll just take you through some cases on a few aspects of employment law. Now, let's have a contract of employment. Now, in the case of Mr. Habib and Coral International Limited and Abel versus Trevi Foundation, presented interesting scenario where the National Industrial Court intervened to afford equity to workers injured in the course of employment and whom the employers, in an apparent bid to avoid liability to pay compensatory damages, turned around to contend were not under their employment. This is very common nowadays. Now, the court held that an employee need not necessarily prove his employment by a written employment letter to maintain a claim against an employer. The court in both cases noted that even though the claimants did not show any letter of employment from the defendants, a contract of employment could be properly inferred from the conduct of the parties. You know that I had earlier said this. Unfortunately, there's a decision of the Court of Appeal which was delivered earlier in the year, which makes light of this principle that have been laid down by the National Industrial Court. But of course, every case is authority for what it decides. That decision involves an international oil company. And then the international oil company had employed some employees, transferred their employment to labor contractors after employing them. And then when they were terminated, the employees sued. And the court said, well, you were not employed by the international oil company, you were employed by the labor contractor. You have to be careful in this case, and I've deliberately not put that case here because it's one of those decisions I am not very happy about because it really takes us back several light years because the law on contract of employment was slowly building to where we could ascertain, what is now known as triangular employment relationships or even co-employer status. And that decision just throws back to, so we're still trying to come back little by little, and we're looking at how the National Industrial Court would take the matter up going forward. But it is safer for you, like I said at the beginning, give your employees a contract of employment within 3 months of their employment with you. The contract must state the nature of their employment, must state the duration of the employment, must state the wages they are entitled to. All of these are provided for in the Labour Act. Now, you cannot refuse to give them employment letters and then seek to benefit from that your refusal to give them employment letters. Then again, the employment handbook. Many times we've seen situations where lawyers come to court to say, well, this thing he's saying is not contained in his employment letter. The employment letter is sacrosanct. No other documents should be interpreted into the employment letter because it's the employment letter that's the contract that binds the parties. And then they begin to put it to you and put it to them. The position of the law is simple. It is not just the contract of employment that, in fact, let me put it this way. What is considered the contract of employment is not just the letter of employment. It is the letter of employment, the employee handbook. It is all the internal policies that are operational in that company that constitutes the contract of employment. So long as there is a rule that you needed an employee to abide by, even if that rule is not stated in his letter of employment, it also forms part of his contract of employment. If there is a benefit that should inure to an employee, even if that benefit is not strictly stated in his letter of employment, so long as it is contained in a document, it is part of the contract of employment. So that when you have created, let's say, a gratuity policy in your company, even though there is a pension, you decided that you still want to be more gratuitous. So you set up a gratuity scheme separate from what is applicable under the Pension Reform Act. And then, this employee has worked with you and many things already endorsed to his favor. Then when he resigns, you now say, well, that was not contained in your contract of employment. It was just the company was just trying to be kind to you. And I've seen many situations where companies have promised a lot of things, and the amount of money standing to the credit of employees in those companies is staggering. And the entire capitalization of that company or the entire money standing to the credit of that company is not even up to 10% of what they promised that they would pay employees of exit. So you find somebody who has worked in the company for 25 years, and the only reason why he worked there for 25 years was because you promised that you're going to pay him all of these things. And then when he's trying to leave, you now find out that you don't even have the money to pay him what you have promised to pay him. So you have to be very careful, and you will not be able to wriggle out of it because it does not contain the employee's contract of employment. So I believe you'll be able to see that all those things in the slides later. Now, disciplinary hearing. Now, if you're going to discipline an employee, and maybe I should start from performance evaluations. You see, if you want to terminate an employee's contract of employment on performance-related reasons, you must give him an opportunity to improve on that performance. That's why you have performance improvement plans. You cannot just tell an employee, oh, you're not good enough, leave. Of course, there's a window for that. That's during the probation period. There's a window for that. But even during probation, you must place them on performance improvement and let them know of the outcome of their performance before you then say, oh, you can leave. So many times you say someone is going to be on probation for 6 months. You do not assess him within 3 months. You wait till it's 6 months and then you say, oh, you didn't do well, go. No, you should give them an opportunity to improve. So your assessment, even during probation period, this is arguable because there are those who argue that, well, the essence of probation is to let him know that he's still being tested. So if he doesn't do well, we'll send him away. Question, how would he know that he did well or did not do well if you did not put him on a performance improvement plan or notified him of the extent of his performance during the period of his probation? So that's that. If you're going to dismiss an employee, this is the other part, for infractions that they must have committed in the course of being with you, you must give them an opportunity to be heard fairly. This doesn't mean you will set up a mini court in your office. No. Giving them a query and waiting on them to respond to the query is enough. In fact, if you issue a query and the employee chooses not to respond to the query, it doesn't stop you from terminating their employment or dismissing them. Fair hearing doesn't mean that they must be heard. No, it is that they must be given an opportunity to be heard. So an employee who doesn't take that opportunity and is fired cannot come to say, oh, you did not give me the opportunity to be heard. I gave you the opportunity to be heard, didn't take the opportunity. There's something called condonation, and employers do it a lot. And HR departments, you have to be cautious of this. You would have condoned a wrongdoing if you fail to take the action that you need to take to put that erring employee in check. So an employee steals, you don't do anything about it. You don't issue him a query. You don't, and of course, mind you, when I say issue a query, it's not word of mouth query, it's a written query. You don't issue a query, you don't do anything. Then 6 years later, when the employee wants to resign, you now remind him, actually, you remember that time when they said you stole. The value of that thing that you stole is 40 million naira. We're deducting it from your exit benefits. That would be wrong. The court would find that you have condoned that, bad habits, and you have lost your rights to, seek any redress under that. Now, let's quickly move to training bonds, and I'll deal with this very shortly. Sometimes you need to train your employees, but because everybody wants to japa, then because japa is happening and bigger opportunities are opening elsewhere, you are wondering how you will secure this your investment in your employees. Training bonds is one of the ways to go. An employee who doesn't want training bonds should not benefit from it. It's as simple as that. If you don't want to, have to be trained by a company to occupy a particular position, then don't allow them spend money on you, right? But when the company has spent money, and of course, I'm going to take this from two angles because it's one of the ways you can retain some of your talents and make sure that they at least stay with you for a number of time. Of course, there's a other bad side of it from the employer's perspective. When you inflate the value of your training, how is it that you directed an employee to go find out on Google how to use an Excel sheet and you value it as 5 million naira? Really? How? The employee will use his own data, his own mobile data to access Google to ask those questions. And somehow it's found its way into a document where you claim that you have spent the sum of 5 million. Which data plan did you buy that was that expensive? So of course there should not be inflation of the bonds. The value of the bond should be a truthful depiction of what you have really spent on training that employee. And of course, there must be receipts to show, because many times employees go to court to say, well, it is a restrictive covenant on my agreement. This employer is trying to stop me from moving forward in life. This employer is my village people doesn't want me to go forward, court decide that this training bond is unlawful, it's a restraint of my right to my career, it's a restraint of trade clause, it should be held to be non-binding on me. Then the court says, well, you signed it. So let's look into it now. Let's see what is contained in the training bonds. Then they now start looking at the line items. And then they see that you've said somebody that took night bus to go to Kano, that the amount of money spent on night bus to Kano was 2 million. Then the court will begin to see that you're not being truthful. And then they say the amount that you say the person you paid for the person to be trained. And then they see one ridiculous amount, they find that you're not being truthful. Sometimes the trainings are even done in-house. And there is no proof that any person was paid to carry out that training. It is just you setting up fictitious trainings and binding your employees to, restrictive covenants that will stop them from moving on. But if the trainings are sincere, for instance, you have airlines sending their pilots for further trainings abroad, and they can show the amount of money they spent. And then they say, well, based on what you earn, it will take about 3 years for this amount to spend on you to be amortized, right? That's reasonable. The employee then has to stay those 3 years. If he doesn't stay, then he has to pay back the, the unspent amount of the bond. And many employers do it. If they're going to poach someone out of the organization, they want to find out, are there restrictive covenants binding this person? What are those restrictive covenants? Okay, what should we do about it? We are willing to offer you XYZ amount of money to take this person from you. Those are, very different things. But training bonds, yes, you can use them as a way to hedge. And when they are there, when you have training bonds, you have to ensure that they are truthful and they properly depict, what was actually spent. And then the employee can be made to amortize that bond for the period that they have spent with your company. In conclusion, I'll say what I said earlier on. Said Mali, when he was Chief Revenue Officer of Ceridian, said the HR department is the most important department in the company. From recruiting top target talents to employee engagement, relations which must be sensitively handled, lest companies may soon have attendant operational issues to deal with. Building, engendering, and sustaining a top corporate culture, it all starts and ends with the quality of the HR in place. HR must get things exactly right. Thank you very much. That will be all from me for now.
Thank you so much, Barrister. This has been enlightening. This has been exhaustive. This has been, back-to-back quality from the opening sentence to your conclusion and closing thoughts. Thank you so much. We'll be taking a few questions, comments, and also contribution. I have one question already, Barrister, and the question is that if in typical employment contracts, you have something like 4 weeks notice or 1 month basic pay in lieu of notice. 4 weeks, so let's use that as the example now. 4 weeks notice or 1 month basic pay in lieu of notice. How would you treat a situation where the person now wants to give 2 weeks notice? Note, the contract clearly stipulates 4 weeks notice or 1 month basic pay in lieu of notice. Does the organization have the right to say, no, you can't give 2 weeks notice? You either give me my 4 weeks notice or you give me my 1 month basic pay in lieu of notice? That's the first question.
All right. So this happens many times. This is one of those situations where, as HR, you can actually deduct that 2 weeks value. So if the contract says, give me 1 month notice or 1 month salary in lieu of notice, it's a contract, you signed it, you were aware of that provision, you must abide by it. If you are trying to give lesser notice, even if by 1 day, you must pay for the value of that day. that you are not going to be available. So if, for instance, someone is supposed to give you 1 month notice and then they give you 2 weeks notice, no problem. He has earned 2 weeks salary because you have told him ahead of time that he's going to have to pay you for, the notice he does not give. So if he gives 2 weeks notice, no wahala. At the time when he's supposed to earn his exit salary, you take out the 2 weeks from that salary and you use that as, the penalty for his failure to give you the full notice he's supposed to give you. The other tricky one is when they just up and leave. They don't give you any notice, nothing, they just leave. When they do that, you're actually entitled to, to take an action to recover that. Now, many people will say, what exactly is the salary that I will now go to court to recover it? It's something. He's not just going to pay back that money. He's also going to be made to pay the value of the money you used in trying to get that money back from him. And it will be one of the reliefs you would ask from the court, and the court will be bound to give you back that money. So cost of the action, cost of engaging lawyers to take on that action, everything that employee, and of course, I know that no employee will be stupid to see a demand letter from, let's say, the legal department of the company saying you were supposed to give us 1 month notice, you didn't give us 1 month notice. Therefore, haven't left the company, pay us the sum of XYZ amount as salary in lieu of notice. If you fail to do so, we'll proceed against you in court and we'll seek the following: salary in lieu of notice. Number 2, cost of the action. Number 3, cost of engaging solicitors. And you will value everything with a note from, maybe the outside counsel or the external counsel you use, charging that particular sum for that. There's no employee that will be so stupid that will see that kind of letter and not respond positively by paying back that salary in your notice. If it goes beyond that to court, then the employee is going to be made to pay the full value of what you have claimed.
Thank you so much, Barrister. That was really, really insightful. We have some questions. So, Barrister, you may just want to browse through the chat box so that you can see some of the questions you can respond to. However, HR with great grace has a question. Please be direct and brief. We are giving you permission to unmute and ask your question. HR with great grace.
Okay, thank you very much, Mr. Oluyemi. Thank you very much, Mr. Emmanuel. Indeed, that's really been a good session and we've learned a lot. Thank you so much. Okay, so this is my question. Okay, I have an employee who had an accident and we got to know that he was actually drunk. And that's because at the venue where the accident happened, even the policemen there said they've always warned him and he was smelling of alcohol. And one of our AGMs also attested to it. So he got back to the office and his line manager gave him a query. But when he will submit that query to HR, he said he didn't take any alcohol. So we did a DC for him. And at the DC, he said he only took agbo. So the question I asked was, okay, so you took agbo to the extent that it was smelling all over you, and you collided with someone else's vehicle. What if those people had died? A woman with her 3 children. Are we going to be saying the same thing? Okay, so now upon looking at the sanction grid of the company, initially when I was asked, I said it definitely is dismissal because even the VIO, if they catch you under the influence of alcohol while driving, definitely is like a jail term and all. So how come I'll still keep you in this employment? So, and of course, my organs have said this cannot be tolerated. We need to ensure that the company is sane. So when they read the sanction grid, it was 2 weeks suspension for drinking on duty. Now, what we now reinterpreted it to was drinking on duty. Let's assume you are not driving. If you are not driving the company's car or on the company's bike, we can say drinking on duty. That one can still be tolerated. But this one, you are handling lives. If you are died, won't you be looking for how to pay your family and all? So upon that premise, so I did a report sent to the MD to approve, and the MD rejected, saying the guy must go. Now, I didn't know what to do at the point because I had to delay it a bit, looking at the fact that the DC, of course, the union chairman was there. Initially, I didn't want him to be there. He said it will not hold except he's there. So let me ask this question. I don't know. So for junior staff or any union, any staff that joined union, if there is a DC hearing, is it a must that the union chairman should be there? Okay, that's by the way. So now I actually now had to give him a termination letter, but it carried services no longer required. And immediately I told my finance team to prepare his check so that should in case there's any lawsuit, at least we paid his in lieu, his prorated salary, his leave allowance, 13th month and all. That was what I did. But of course, I had a meeting with the union guys. Now the external union guys came. And the first thing they would tell me is, yes, they heard that we are threatening their staff. And, I was like, threatening how? So apparently they've gone to report that issue to them. And these same union guys are asking that they are interested in the case. They want to know what will happen and all. So I want you to advise me. I don't know, what I took, was it right? Or how should I have addressed it? And what should I, in fact, even these union guys, you won't believe they were telling me that
I'm about to report you to the union. You have used too much time. So union member have started chatting with our guy.
Okay, so fine.
You don't do. I don't take a go. You don't do.
Thank you, sir.
All right. So, questions. You need to. So when things like this happen, the first thing you need to do is to get all the evidence you need to deal with the action. They said he smelled of alcohol is not a drug test. So if you had found yourself in a situation where this escalated to litigation, the only evidence that he was under the influence is the result of a drug test. So let's take that out of the way. So without that, you really cannot say that he was in that accident because he was under the influence. That there was a policeman who said it. The policeman himself might have taken something that might have been smelling in his nose. And what he was smelling might not have been from that influence. I'm just playing the devil's advocate to let you know how these things eventually play out, right? So a drug test must be done. Now, what happens when an employee's negligence leads to loss for a company? I've also come to the issue of the DC hearing and all. I have said earlier on that Section 5 of the Labour Act allows certain deductions. If an employee's negligence has led to loss for a company, you can value that loss, inform the employee of his negligence, and let him know that that's the amount that the company has been exposed to will be deducted from his salary going forward. However, it will be to the value of 33.3%, which is 1/3 of what his salary is. That can also be a punishment for him until the sum is fully taken out from his salary. Now, let us go to the issue of the decision to be taken. Whatever decision you are taking must be in compliance with your internal policies. Because an MD wants something bigger or something, let me not say sentence, a decision that is more grave, does not mean that HR is compelled to go beyond what is stated in your internal policies, like your handbook. So If the sanction stated in your handbook is that someone who is involved in this thing would be liable to 2 weeks suspension without pay, then 2 weeks suspension it is without pay. Now, whether union can be involved in DC hearing depends on the employee. He's a member of a union, right? Not just that it depends on the employee, it depends on what your handbook says. So some handbooks will say that during DC hearing, the employee is allowed to come with a representative of his. If your handbook, the fact that someone is a union member does not mean that his individual obligations must be subsumed in the collective union obligation. Just the same way that employee as an individual has employee rights. And in when he joins his union, he has labor rights. The same way the employee has employee obligations and labor obligations. So the union cannot insist that they must attend DC hearing if there is no provision in the handbook stating that the employee has a right to have someone represent him during DC hearings, in which case it would not be necessary for the employee to have a union member represent him. If there is such a provision allowing him to have a representative, then he can elect to have the union members represent him during the hearing. Well, I don't know if I have answered everything, but from what I listed out,
You have
I
tried,
think
sir.
I have.
So we'll take Nonye next. Nonye, please, 1 minute, or the union will take out your voice. Nonye, please unmute. 1 minute. I'm actually typing, tracking you literally.
All right. Good evening, everyone. Thank you very much, Emmanuel, for your presentation. So I won't take much of your time. I have like 3 questions, but they are very brief. So referring to the first part of your presentation, when you talked about, some certain professionals leading or working in the HR department, I don't know if you're aware, there are some companies that also, use the services of a legal person. So you see job positions like HR, legal officer, or somebody that has that legal backing, right? Made as the head of the department. So I want you to speak on that. Secondly, um, I'm in a WhatsApp group, right? And we were discussing about, everything that has to do with employee relations. And someone was stating that if you want to send a query to an employee, let's say, for instance, Mr. A, you were given a deadline to present your project in before 72 hours, you weren't able to do that. Can you tell us why a disciplinary action will not be taken against you, something like that? And when we're having that discussion, that person said that that clause of why should disciplinary action not be taken against you is wrong, because it defiles the aspect of being a judge in your own case, instead of allowing the party that you're trying to get that feedback from expressing himself. So what the person was saying is that that clause should not be there invariably. And then the third question has to do with termination of employment. So in the case of voluntary resignation, so in the former company I work with, there are some employees that are funny. You would give them, what they call it now, work tools, you give them cars and all that. And then some of them, once we have accepted the resignation and it's time for them to go, you have to literally be chasing them to return these items to you. And so we decided that, okay, upon when you complete the whole termination process of returning the work tools, carrying out your handover processes and all that, that is when we'll release your payment. So whatever payment that is owed to you, maybe incentive, salary, or whatsoever. So I just want to know if that practice is okay to be done in such situations. Thank you. Thank you very much.
All right, thank you very much, Nani. So first one, can legal be HR? Does the legal person have HR qualifications? If the answer is no, then my answer is no. It's simple, really. That you're a lawyer doesn't necessarily mean you can work as HR. There are trainings that HR personnel have to undertake to be able to fit that role properly. The fact that someone is qualified as a lawyer, and you'll be shocked. I have a mentor who speaks at CIPM events very well, like very, very frequently, right? Recently, CIPM, they had a rule that if you're going to speak at the event, then you also must be um, qualified as a HR specialist, right? He had to take HR training with CIPM to have CIPM qualification to continue as a resource person. I don't know if you understand. So you cannot simply say that because you are a lawyer, then you fit as HR. That's that. In fact, you'll be shocked that many of the issues that we've had to face in dealing with non-compliance with HR requirements, it mostly happens to people who should know better. Let me not say beyond that. So the fact that a person is a lawyer does not mean that he can just be HR. What his qualifying certificate gives to him is a right of audience in court and to practice as a barrister and solicitor of the Federal Republic of Nigeria. If you check that certificate, there's no HR there. So the person should go and get HR certification. That's that. Why disciplinary action should not be taken against you? So in preparing queries, you have to be careful that the words you use do not convey, that you have decided that the person is guilty. So in preparing a query, you have to be careful in presenting it so you don't pass on a sentence in a query. Let me put it this way. So you don't state that you have made a decision in a document that should ordinarily be a query. There's a case that's currently pending before the National Industrial Court. What happened? This employee was given a query. It was a query. And the HR in the same query said that the query will be filed in the employee's file. That's a decision. So it already shows bias. It shows that you have made up your mind, regardless of what this employee does or says in his defense. You have already said it's going to be in your file. So you have to be careful. Now, the phrase why disciplinary action should not be taken against you, I don't see what the big deal is really about that. I have seen a lot of queries ending with tell us why a disciplinary action should not be taken against you. And I don't see why that is prejudicial in any way, right? So the court will even give you, during criminal actions, the court will give you an opportunity to say whether you are guilty or you're not guilty. If you say you are guilty, then sentencing follows. If you say you're not guilty, then trial begins. So tell me why I should not take disciplinary actions against you. It's not so grave as it seems. Yes, should it necessarily be there? Maybe not, but I've seen it in many queries, and I don't see it as stating that the person is guilty. You're only telling him to give you the reasons why you should not, take action against him. But then again, if you follow what I said earlier on, you must ensure that you're not doing anything that conveys a decision. So tell me why I should not take a disciplinary action against you would almost make it look like as if you have decided that a disciplinary action should be taken. So tell me why it should not. I mean, I'm saying I've seen it in a lot of queries, and it's not as grave as it seems. But yeah, if there's a way to present it better, then present it better. In preparing queries, what I always tell people to do is to be sure of the allegations you are making. Now, there must be a preliminary investigation. Maybe there was a whistleblowing complaint, right? There must be a preliminary investigation you have done. You will tell him that, or you tell that employee that, well, the preliminary investigations we have done, carried out, shows the following, that this possibly happened on so and so day, that this may have happened on so and so day, that this. Now, please submit a defense in your favor against the allegations or against the preliminary findings of the investigation team on so and so day. so that you convey it in such a way that nothing looks final, nothing looks like you have made a decision already. So maybe that person has a point, but honestly, it's not that brave. Then post-employment obligation. Please, let me say it this way. The law is that exit now, the salary in lieu of notice or salary earned must be paid contemporaneously with the exit of the employee. Now, if the employee has other benefits, those must be paid within a reasonable time after exit. So there are two things that you must differentiate. The first is whether it's a payment in lieu of notice if the person has been terminated and you okay, can you hear me now? Yeah, I think I was muted at the time. Now, whether the employee has, resigned, or let's say the employee has been terminated, you haven't given him, you know, the opportunity to serve out the usual time he should have served before the exit becomes final. You must pay him his salary in lieu of that notice he should have given. Contemporaneously, that means at the same time you are terminating the employment, you must. And there is the case of Chukuma versus Shell Petroleum Development Company, right? This is where this principle was first laid down by the Supreme Court. So it is taken very sacrosanct in employment law cases. Now, other entitlements, you should now pay those within a reasonable time. That is what the wages convention says. You must pay those within a reasonable time. Now, this is the one you can say you are holding on to, but don't write it in a letter that you're holding on to anything. Just inform the employee that his salary in lieu of notice has been paid and that he's entitled to XYZ amount as his exit benefits. However, he should kindly commence his exit process with HR. Or you can say, kindly note that the company has commenced the process for paying all your exit benefits as soon as you complete your exit clearance with HR. But you must pay him his salary in lieu of notice. Now, if the salary in lieu of notice is the only thing he's entitled to, pay him. Inform him of his obligation. Of course, you know that in employment law, there are pre-employment obligations, employment obligations, and post-employment obligations. So you inform him of his post-employment obligations, right? If he fails to comply, like he has a car, he's supposed to have returned, he didn't return it, that's conversion. It's a criminal and a civil case of its own. So you can actually take up that case against him. Many times employers don't want to have to do that because they feel that it's waste of money and to just make a lawyer rich. It is not going to be your own money you'll be using. You just write the employee, like I said earlier on, tell him what the likely exposure would be for his refusal to return the company's properties. And if he still fails to do that, sue him. And that's just it. And then you recover every other thing that you're supposed to. But don't hold on to. Of course, the last time I was here, I spoke about a case where what the court held as an unfair labor practice was the fact that the employee's final benefits were withheld because the company said he did not do a proper handover. And the court said, no, it's unfair labor practice. Pay him that's his final benefit and pay him additional damages. So you don't want to be in a position where you're on the wrong side of the law, really. So salary in your notice paid, then any other entitlement, pay within a reasonable time, inform him to go complete his exit clearance with HR, but you must pay his salary in lieu of notice or any end salary at all. I hope that helps.
Thank you so much. I think we'll take just one or two more questions, and that will be from Wofai and Akorede. We'll take Wofai first. Wofai, I have prayed that you will be brief. Answer my prayer, please. Hello, Wofai. Thank you.
All right, okay, good. Yeah, good evening, everyone. Barrister and Mr. Luyemi, thanks for the opportunity to speak. Great value added. But I have a question that borders on abuse. Okay, so you have this employee who was reported to have abused a certain lady. By abuse, now I mean sexual abuse. Okay, and this didn't get to HR until like 6 months or 4 months after. And then, of course, as part of the code of conduct, the case was referred to the DC. And at the course of the investigation, the said employee now had to tender his resignation. Okay, my question is this. Does the law, is it right for an employee to tender resignation when being investigated? And then part of the things that the DC had recommended was a medical investigation on the said person that was abused. Okay, the bill was sent to this other employee. Is that right in the face of the law? Is it the right thing for him to foot the bill? And is it also right for him to resign at the time where he was under investigation? Because the thing was, his resignation letter was rejected with the emphasis on the fact that he was being investigated. So I want to know, what does the law say about this, sir?
All right, thank you very much. So let's make it very clear. An employee can resign anytime, and the company does not have any discretion to exercise with relation to an employee's resignation. I know it sounds harsh, right? But I know what I'm saying. I've been burned over this issue, and I was representing, a bank, and a lady had resigned. I mean, I can talk about it because the case is reported on the portal of the the judgment portal of the National Industrial Court. The lady resigned, and the company said, "Look, we have already terminated her employment, but someone tipped her off." Now, for bankers, it's a sensitive issue. If you're terminated, you have to inform CBN, and of course, you may be blacklisted, right? So she wanted to avoid that situation of being terminated. They had already typed the letter. It was on the desk of the HR head, just for him to sign. Then someone else in the HR department tipped her off that, "Hey, madam, resign, So she resigned on a Saturday, right? And the company, the bank wrote her back and said, "No, your resignation is refused." And all the explanation we tried to give to the court to show the court that, look, maybe there should be an exception. The court said, no, if an employee has resigned, they have resigned. If you force them to stay, then it becomes forced labor. So that's that. Now, if an employee resigns during DC hearing, what's the nature of the DC hearing? Is it something that outlives the resignation? What I'm saying is this: leave the resignation. You don't have any discretion over it. Even when I see a lot of HR practitioners writing to accept resignation, except the person has been such a star employee and you just want the person to feel good about themselves, or you are so happy that this person has resigned and you really need to let them know that, please, we are so happy that you have resigned. Thank you for your resignation. You can write those things, but to be honest, there's really no discretion to exercise with relation to resignation. They resigned. The resignation becomes effective on the day the employee says it becomes effective. It's their right to work for you or not. Now, yes, there's a pending DC hearing and they have left. What's the nature of the DC hearing? Does it outlive their resignation? For instance, this is sexual assault or sexual harassment or, some, sexual conduct that or is likely to lead to loss for the company, right? These kinds of things outlive that resignation because regardless of whether or not the person has resigned, it has not taken away the right of action by the person who was wronged. The question is now, who is pursuing this right of action or who is taking this right of action further? This person has left us. Yes, this thing happened during the pendency of this person's employment with us, but this person is no longer under our employ. Now, what the company just needs to do is to make sure that they are not posturing as if they are in support of the person who has left. Because in that case, it means that you are ratifying that wrong act. There is the case of AGK and Microsoft where sexual harassment occurred because of the lady's employment, and then she informed the company that, look, this is what is happening. The company did nothing about it because the person who did that act was the country manager. So basically, he was in charge, right? And he took no action about what had happened, right? The court said, look, for your refusal to take the action you ought to have taken, you ratified this wrong. So you are also liable for what has happened. So long as the company is not posturing like it's in support of what has happened, the company can actually encourage the to institute an action for the sexual harassment and, be part of the proceedings in support of that person. So don't be like the, pilot who washed his hands. Washing your hands at that point would almost look like classification. The fact that the person has gone doesn't mean that you cannot, take certain actions. Now, because it's sexual harassment, it's under the rules of the National Industrial Court. You can take it on at the National Industrial Court. But there are certain things like assault, maybe someone slapped somebody, those, there's what we call torts in law, TORT. The jurisdiction of the National Industrial Court over torts is a little bit dicey right now. There are competing decisions of the Court of Appeal whether or not it's, actions like that should come before the National Industrial Court or go before the regular state high courts and all of that. Because if it's sexual harassment or harassment in place of in the course of employment, then the company can actually encourage that person to file an action against the person who has harassed them. And of course, the company gives this necessary support if the HR person needs to testify, to the fact that the company has already started taking steps, and then the employee resigned. The HR can go ahead and testify to that effect in court, so that the company is not seen as having, ratified any of those wrongful acts. I hope this.
Thank you so much. Our final question for the day. Daniel Akorede, you have the floor. Barrister, I can just come through the chat in case there are things you want to speak to quickly. Daniel Akorede, final question for the day, sir. Okay. Maybe Daniel left his hands up intentionally. Let me help him put it down so that it won't be paining him. Okay.
All right. So
Yes, Barrister. Any question you want to just respond to?
Yes. So I see this question in the chat box. There is this employee who had an accident on his way to work and had fracture on his right leg. As a result of the fracture, he has not been able to return to work since there's supposed to be a number of years, 3 years, and has been collecting his full salary for this unproductive 3 years. Please, what's your advice on this? First question, are you NSITF compliant? If you're NSITF compliant, then you have the right to terminate his employment. But then, the way I'm seeing it, you are already out of time to report the accident. So here's the thing. If you're NSITF compliant and you're paying your monthly payroll contributions into the fund, right? This is the reason why you are making those payments for situations like this. When an employee has an accident and becomes unproductive, that employee is entitled to compensation. The compensation paid to him by NSICF is supposed to be enough to assuage his suffering. So many times I say that it is like many times, the employers are maybe too kind, sorry to say it that way, too kind to take the action they need to take. What if he died? Would you continue paying him salary, continuously, even though he's dead? You won't. So now he's injured. This is an injury that makes it impossible for him to work for you. So what do? you can terminate his employment after you have fully processed his compensation for the NSITF. The problem is that if you're not NSITF compliant, then that's another thing entirely. So, but you can hedge the risk. Call him into a meeting. Let him know that, look, there is a law that entitles you to compensation, right? This is the amount of money you should ordinarily be paid for an injury of this nature. The company is willing to pay this money to you in full and final settlement of, the losses or the injury you have suffered. And then you pay that money to him. But then you don't just pay it to him, you make him sign a mutual separation agreement that allows him go out of your or exit your company peacefully and relinquish his rights to take on any further claims against the company. I believe that's a better way to handle situations like this. I'm trying to go through
All right, let me
this.
ask my question now. Thank you very much, Mr. Emmanuel. For
welcome.
me, it has been an insightful session. So I want to ask, what's the perspective of the law on no work, no pay policy? We actually designed this policy for some categories of workers in organization. They fall into the third-party staff. They are the factory hands, the pickers, and the store hands, and all. So we had an audit earlier this year where the auditor was telling me that we're not supposed to deduct their salary for days they didn't come to work. So I felt I understand the fact that we're supposed to get the consent of the labor authority and all that. But I felt, how do we handle it whereby you don't come to work for a certain number of days, and you're talking about staff strength of over 400, and about 20% don't come to work for 10, 15 days in a month, and you still have to pay them for those days they didn't come to work. Of course, considering the financial implication on the payroll and all that. So I'm trying to see how do we come up with solutions to this? How do we address it from the angle of the law and at the same time from the angle of the employer? Thank you.
All right, thank you very much. So no work, no pay policy in your employment handbook is perfect. There's nothing wrong with having a no work, no pay policy, right? So long as you have not, been negligent in providing work to that worker. Now, why has the worker not worked? Did you provide work to that worker and the worker did not do it? If you provided work to the worker, then the worker did not do it, then of course nobody can earn for what they did not do, right? So if you have a situation where in your handbook you have stated clearly that working hours are from so and so time to so and so time, you don't have a work from home policy that is making those people stay away from work, right? It is just that they refuse to come to work when they should have. Of course, there has to be a policy in your handbook that addresses situations like that when someone's absenteeism, from work without any authorization to do so. So when you have situations like that, you can actually penalize the employee for that, right? Sometimes it's tardiness. They come late to work. You have a policy that says if you come late to work for 3 consecutive days, a sum of so and so amount will be deducted from the salary. It's a contract that the employee has signed. So the employee is bound by that. So long as this policy is not something you're bringing in after you have employed them and they have not consented to it. So that's just the difference. But no pay policy, even when employees go on strike, it's also lawful. So there's nothing stopping you from a no work, no pay policy. I'm seeing a question here that says, how about employment as will clause? Please, there's a reason why I decided I must answer this question. There is no such thing as employment at will in Nigeria. Employment at will does not operate in Nigeria. It operates in the US, I agree. But in Nigeria, the ILO Termination of Employment Convention is in operation, which says that there must be a valid reason for termination of employment. Employment at will is really just that you are working at the pleasure of your employer, and your employer can decide at any time to terminate your employment for no reason. That kind of clause in Nigeria does not operate. If it's in your contract of employment, it is proof of unfair labor practice on its own. So if it's there, I'll suggest you revise your contractual documents to make it to take out employment as real from that, so that you don't find yourself in a situation where you are at a loss. So I'm looking for other question. So someone asked a question about whether an employee under DC hearing can resign. Yes, you can resign, and the employer cannot say the resignation is invalid. In a situation where a query was given to an employee and the employee refused to answer the query, what can the HR do? Like I said earlier on, it's an opportunity for fair hearing. Now, fair hearing doesn't necessarily mean that they must be heard. No. It is that they are seen to have been given an opportunity to be heard. Those are two different things. So if they have been given an opportunity to be heard and they don't take that opportunity, then they have forfeited the rights to fair hearing and they cannot be heard to complain about it. Someone has asked, are there statutory provisions that allow for payments of leave allowance to an employee? This is entirely contractual. If your contract of employment or your handbook states this, then it's binding. So once it's taking 2 weeks in your notice from an employer that did not give us, okay, I think this has been answered. Good evening, barrister. Do we deduct 2 weeks basic or 2 weeks salary in lieu? I think this has also been answered. In the case of an employee in case an employee wants to give 2 weeks notice from his leave, is that permissible? Well, so again, this depends on your contractual document, especially your employee handbook. If the employee has earned those leave days and then wants to resign and says, I have earned XYZ leave days, I am collapsing these leave days into my notice period and I am leaving. If your handbook does not say that is not permissible, then it is permissible. So you also want to consider reviewing your handbook. When an employee refuses to pay for the salary in notice when resigning without giving due 1 month notice, what can the HR do? If he has not given notice and he resigns, if you are still holding his salary, then take it in lieu of the notice he's supposed to have given. If, of course, I've answered this earlier on. Please, in the case where a staff was supposed to be confirmed after 6 months probation, yet not a word from the organization, can that said employee give 1 month's notice period while tendering his resignation? Well, I don't see why not, except if the clause says that you are entitled to less than 1 month notice before confirmation. So if, for instance, they say during your probation period, you have to give 2 weeks notice, and then after the probation, the company doesn't communicate to you that your probation, you have now been confirmed, then 2 weeks notice it is. But mind you, for employers, and HR should also note this, if you place someone on probation and you fail to communicate to them that the probation period has ended and they have now been confirmed, and there are certain benefits they should earn at confirmation, and then they resign, let's say 8 months after the probation, and you have still not confirmed them, the law would deem it that you confirmed them. So your silence would not actually work for you. You cannot use your own wrongdoing as a shield. So, okay, barrister, can we just issue a letter of termination? Service no longer required without stating the reason? No. The ILO Termination of Employment Convention, which is applicable in Nigeria by virtue of the Third Alteration Act of the Constitution, is to the effect that you must give a valid reason for termination of employment. You must give a valid reason. So now there are instances where the employer might have failed to give that reason for termination of employment, right? The employee is required under the termination of employment recommendation to, by a written memorandum, request for the reason for the termination of employment. And if the company still fails to give that reason, then the termination is invalid. Of course, if the termination is based on performance, then you must have given the employee a performance, an opportunity to improve on that performance. And if they have failed, you notify them of where they have failed and how they have failed, and that being the reason for terminating their employment, not just getting up and terminating their employment. In the case when an employee gave a stipulated notice period and was present during the notice period, but he or she was not paid as on when due, and when complained bitterly about it, he or she was seen as being rude. And till now, something last year up till now, and the company seems to be popular. What do we say about that? Okay, well, I think I get what you are saying. I think many times many of us don't want to look. The law says you can, if you have a grievance against somebody, you can take it up as an issue in court. But many of us don't seem to like to go to court. People just want lawyers to die for. Why? You can actually sue that company and you will get your termination benefits as well as damages for their wrongful actions, really, including the money you paid your lawyer. In fact, there are lawyers who will take it up for you on a contingency basis, and there is, even if you don't have money, there are groups and non-for-profit organizations that can do these things for you for free. So that's just that. Looking for good evening, please. Is it unlawful for a company to set its own policies to reflect its notice of exit for senior leadership as 2 months notice or 2 months in the office? Absolutely. Absolutely. Whatever the company says on this issue is, you negotiated your contract of employment. Even if it is saying that the company had a higher bargaining power, it still would not stop them from saying, look, we consider you a senior employee, and your exit is going to be crucial to our operations or detrimental to our operations. So we need time to replace you. So there is no law that says it must be so and so amount of time, right? There's no law that says that, especially for senior employees. Someone said, I'll need the title of the case you just mentioned. Unfortunately, I don't now know the case that this person is referring to. Maybe the person can state what the case is. Barrister, can you share your contacts? Well, I'll leave that to Mr. Diosho. Is it permissible for an employee to use leave as in lieu of notice? Okay, I've answered this earlier on. The leave days are end, so I mean, you cannot deprive them of it. Is it right for an organization to? Is it right for an organization not to pay staff because there has not been sales for like 5 months? Yeah. So you are entitled to your salaries as negotiated. Now, if you have not negotiated the kind of employment that makes your salary dependent on sales. So for instance, you're a salesperson and they give you targets and then they say, oh, it depends on, well, even if they give you targets, right? There's a decision of the National Industrial Court. I'm careful not to make it all encompassing, because you are saying this company in issue is a real estate company. The decision of the National Industrial Court on, sales and all these targets for sales and all of that was held in relation to a bank, not a real estate company. And of course, every decision is only an authority for what it decides. We cannot just decide to, apply one case to another scenario if it doesn't apply. But what was your contract of employment? Did it say you earn salaries and it is not dependent on sales made, or are you being paid some form of agency fee or some form of commission for sales you have made, and that's the only payments coming to you? These are the issues. But if it's just outright salary, then yes, they must pay you your salary. Should a core member be given employment letter? It really goes to know issue. The core member already has a deployment letter from NYC. The core member is probably only sent to your organization to, as part of their place of primary assignment in service to the nation. Whether or not you give them employment letters is it really goes to no issue. But if you give them, there's nothing wrong with that. Especially if you want to pay them something. If you're not paying them anything, then your employment letter is a waste of paper. You shouldn't have bothered. I used to pay staff placed on suspension for 3 months after we leave the suspension. Depends on your contract of employment, depends on your internal policy. If your internal policy, and you must be careful, you see, suspension without pay is deemed to be a disciplinary action on its own if your internal document does not state otherwise. If your internal document states otherwise, then you must pay them after you have absolved them of the wrongdoing for which you placed them on suspension in the first place. This kind of practice is very dangerous, and I'll tell you why. Sometimes you place people on suspension and your internal documents say that they will be paid after the suspension is lifted, and then you forget about them. And then the employee remembers like 4 years later, and then he comes back. I'm not even telling you stories. I'm telling you, this is a live case that is before the National Industrial Court. Now, the employee was placed on suspension and the company forgot about it. Then the company was bought by another company and nobody had records of this particular employee until he went to court and showed, because there was a criminal proceeding ongoing in court, and he went through the entire criminal proceedings and was absolved of the wrongdoing and came back 4 years later to claim salaries for the period of suspension. The case is still pending in court, so I can't say anything about it, but you have to be careful. Concerning the training bond, in a case where no external training was done, that is monetary value attached, and the only form of training conducted was just the director training, showing the employee on how to do some tasks, but the management wants to bond the employee for at least 1 year. What is the right thing to do, sir, as there was no value attached to this type of? Well, you can't say there was no value attached to the type of training. If the director trains you, that's value on its own. But if the company, and again, it depends on you. Are you okay with it? If the company is saying we want you to stay an extra year, and the cost of it is that the director will train you on certain things, especially if those skills you are gaining are transferable skills, right? And you are looking at it as, enough value that you're getting to serve the company for an extra year before, for 1 year after the training, right? It's up to you, really. This is really about negotiation, and it's really not about law. So don't negotiate yourself into a bind, right? An employee is terminated based on bad character and negative influence in the workplace. The truth of the matter is that some employees used to behave like, I don't know which word to use, Obanje. So, so I don't see why you can't be terminated based on your bad character, especially if you're not toxic in the workplace. Of course, again, it depends on it depends on what your internal policies say. But again, you have to communicate to this employee. Let the employee know what the service they are doing to the company by their bad attitude or bad character, and then let them, try to see how they can change. And if they are not changing, what can an employer do if the employee resigns immediately and fails to pay the? Okay, I think I've answered this. I think I've answered that.
My
Oh,
lord,
did
I
you
just
okay?
caught someone, so we have to adjourn this meeting. From
And
your
Coach
wife.
Mrs., I was there. I was about to say that would be the last question.
Thank you.
Okay, I
Thank
can
you.
say you don't
Thank
want
you.
my wife to sue you.
Yes, yes. Please
And my
drop
wife
your phone
happens to be
number
a
on the
lawyer
chat
too.
group. And I've let people know that invoice will follow, please.
Because
Please drop your phone number on the group. Ladies and gentlemen,
I see someone has done that already.
thank you so much. Barrister used 5 years in law. He now did law school and he has done donkey years in practice and he's still learning. So probably I know they finish. Wala. But lawyers must shop now. So make sure you have lawyers in your family. Ladies and gentlemen, we are excited, delighted. We feel highly privileged and honored to have had Barrister Emmanuel Abrai for the last 2 hours plus on this program. Thank you so much, sir. I promise you, sir, you will come again by God's grace. If you like, go to Canada. Thank God it is virtual. We will reach out to you, sir. Good night, everyone.
All right, sir. Thank you.
Ladies and gentlemen, let's unmute and say thank you and good night to our barrister. Thank you.
Thank you very much.
Thank you,
Barrister.
sir.
Thank you so much, Barrister.
Thank you,
Thank you
Barrister.
so much.
Emmanuel Abraye, thank you so much.
Thank you very much,
Thank you.
Barrister Emmanuel.
Barrister. Very, very wonderful session.
Thank you, thank you, thank you.
Thank you so much, everyone.
Thank you so much.
No, I talk to Ima.
Thank you,
thank
sir.
you.